Hi everybody, welcome back to Law Hero, and this is contract law, how to ace it for your FE1 and the rest of your career. And before I jump into the nitty gritty, I'd like to say thank you to everybody for all the lovely messages over the last few weeks. Not out yet, but I'll be going through the March 2019 FE1 paper in this video, so if you're interested, stay tuned. So generally the examiners have pretty much the same comments every year, that there is a lack of basic understanding of contract law. The exam is very structured. You have 4 problem questions and you have 4 essay questions, and that is always like 1, 2, 3, 4 are the problem questions, and then from 5 onwards is the essay questions. And obviously my notes are up on lawhero.eu, up on the contract law page. So the first question is, it's a rehash of, I think it may be October 2017 question 2, which is basically somebody who is throwing out a load of fertilizer and they get it for free, and they're so delighted, they say, oh look, I'll give you €200 for that, and they never do. So basically you've received the goods and you make a promise to pay for it after you've actually received them. So because there's no consideration for that promise, you go and look at estoppel, because that's basically the only thing you can do. When contract doesn't help you, you go to equity. Yeah, so that's that. And then the second bit then is like this inquiry. Oh, do you have X product? Yeah, I'll keep it to you. I'll keep it for you till Saturday. Customer rings up on Friday. Yeah, I'll take it, but sure, it was sold on Wednesday. So the company who's selling the product, they make an offer to you. They say, yeah, we have whatever, a digger for 10k, and whatever you don't agree right there and then. You say you'll call them back and let them know, and then you don't do so until Friday and the thing is gone. Then you don't have a contract. Acceptance must be communicated, and it must be communicated in the manner prescribed by the offeror, so you don't get your digger. Now, question 2 is interesting. It's about terms and conditions being incorporated into a contract when this guy goes and get a cinema ticket. And I think we all should be very wary of where the law is going here, particularly for practitioners, you know, because contracts are no longer like they were back in the day. You know, a lot of the time they're signed electronically, they're held on a server, there's a hyperlink to another part of the website, but he never read the terms. And then he falls over a cable and they have section 12 incorporated into his contract. And if it is incorporated, can he bring an action against the cinema even though they have excluded liability in contract tort? Incorporation of terms, to my mind, I mentioned it in my notes, but the Ryanair case, it was an Irish Supreme Court case, and that held basically if you are directed to read the terms and conditions, and if there's a hyperlink or whatever, you don't have to actually show the terms and conditions, they are incorporated. Tripped over a cable that was left out by a member of staff. They're offering a service, so it comes within consumer legislation, certain implied conditions that go along with providing a service, such that cinema provider needs to make sure that they provide the service with due care, skill and diligence. So that would be your contractual action. In any case, the term is unfair because, you know, normally, for example, if you're going, we'll say doing an activity, you know, like a sports activity where you could get injured, you sign a waiver, but it's brought to your attention and you make a positive statement. Yes, I know I could get injured, but I'm signing a waiver notwithstanding the consequences. I don't go too much into question 3 because it's straight out misrepresentation of an investment, and just remember you don't have to do your due diligence, and it doesn't form a defence for the person who's misrepresented the facts. Question 4 relates to damages for food that basically went off. There was no food to serve in a hotel, so they had to close it. And yeah, so my chapter on damages goes through this very well. Claims for lost profits. So lost profits, always remember, is a future looking or expectation loss. That's one of the heads of loss. It's difficult to prove though. And then obviously you have a positive duty to mitigate your losses. And then the second part of the question is, I believe, about penalties. Yeah, so some of the goods come 2 days late and they charge, 120% of the cost of materials transported. Yeah, so basically you just go down through the law on penalties. Penalties are illegal in contracts, and there's loads of case law on that. The leading case being Dunlop tires. So the rule is that it needs to be, if there is agreed damages in the contract, it needs to be a genuine pre-estimate of the loss. And my notes go down through that. Okay, so then I'm just going to briefly mention the essays because they're very straightforward. And actually, if you have my ebook, you'll be covered for this whole exam. So yeah, question 5 is about what approach do courts take when interpreting contractual documents, and leave out the parole evidence rule. I've got a very good answer on interpretation of contractual documents, and the examiner notes as well that people really don't answer this question well. So I think if you were to know this one well, you would definitely impress the examiner. Question 6, what is the difference between a condition, a warranty, and an inanimate term? Becomes a condition. So the condition is one of the three. So the first one's condition. If you breach that term, that allows a party to repudiate the contract. And repudiate the contract simply means you don't do it, or you can sue for damages. Warranty, like when you think of warranty, it sounds like guarantee, so just remember it like that. It's a promise. So if somebody warrants in a contract that the financial information is sound and up to date, if they lied, then we can sue for damages. But we cannot repudiate from the contract, because the contract, as in like I'm buying this company, is still going to go ahead because it's not a condition of the contract, it's just a warranty. And inanimate is something that can't be named, a bit like Voldemort. So just think of inanimate terms as like your Voldemort terms. But basically it's not a condition or a warranty, it kind of falls between the two stools. And the way you remember it is with the Hong Kong Furs case, which is again a mouthful, but it's actually a good case to illustrate what an anonymous term. Really quickly, because I've gone way over time. So question 7 then is the relationship between doctrines of consideration and promissory estoppel. That's so easy. I mean, it's done in my notes. You could literally rattle it off and get really, really high marks. And then question 8, then it's split. You can answer A or B, and just be careful of those in the exam. Discuss the circumstances in which a contract will be declared invalid on the grounds of economic duress, and I cover that under my undue influence and duress chapter. And then the other one is, which contractual principles are used by the courts to protect people who provide guarantees and securities to financial institutions. That touches a little bit on equitable stuff. But basically you look at the presumption of undue influence and how you can displace presumption depending on the relationship between the parties and the duty of care owed between the parties. March 2019 paper was very fair, but I understand why people do fade it. It's all to do with preparation, in my opinion. Okay, thanks very, very much for watching. I'm absolutely wrecked from making that video. Yeah, but that's what you get when you give your heart and soul to contract law on a rainy Friday. Bye. Thank you. Please like and subscribe.